let's get started, guys. Welcome back. All right, so this is our fourth class, just to kind of give you a sense of where we are. Remember, I've been updating the twin sites, so the syllabus has been updated to reflect up through next class. And I think we're pretty much on track with where we wanted to be. We'll talk about the drafting exercise that's due this coming Saturday at the end of class. But there will be a drafting exercise that I think is pretty straightforward, not that complicated. And that will be due by Saturday at 5 o'clock, so we'll talk about that. There's actually no new reading assignment for next class because it involves you just reviewing and rereading the initial pleading. And I'll kind of explain why that is. The spoiler alert answer is that you're not going to be drafting. This exercise for Saturday does not require you to draft a complaint, but it requires you to think about factual allegations, and it requires you to critique a complaint that exists in this packet, in this case file. So that's what I want you to do for this Saturday. For the following Saturday, you're actually going to have to be drafting a complaint. And since this chapter is all about the kind of rules and things to think about with respect to drafting complaints, it kind of will function as the reading assignment for both weeks. So the good news is no new reading assignment for next week. The bad news is there is a drafting exercise, but the good news is it's not that stressful. So that's where we are procedurally. The Super Bowl was yesterday. I realize it's kind of a busy time, right? Like the Super Bowl, for those of you who may be following the caucuses, those are going on right now. State of the Union is tomorrow. But legal drafting is tonight, which is the most important thing. And the thing you've been kind of keeping your eye on. All right, so what we're going to do today is two things. We're going to talk about this reading assignment in some detail, this initial pleading. It's a little boring today. Hopefully it won't be too bad, but I mean, it kind of requires us to go through this reading material kind of methodically. I think it's dry, but I think it's good. I think it kind of accurately captures the things you want to think about, not only when assessing a cause of action, like you get a case file, and before you even start to think about actually drafting a complaint, you're thinking about what are the sorts of things, the facts that I need to gather, what's some of the legal principles that I need to be thinking about. This material will kind of help you take a case file and distill it down to what you maybe need, and then it also will help you put pen to paper and start drafting a complaint. So I think it's very good material. It's very helpful as far as a resource goes, but it is a little bit dry. So hopefully we'll without boring ourselves to death too much. We'll take a break, and then what we'll do is we will talk about the case file that's assigned for next class, and we'll take a look at it. We'll spend a few minutes actually going through it. So you have kind of a good sense of what you need to do ahead of Saturday before you have to turn in your reading assignment or your drafting exercise. Any questions, concerns, comments? All right, well, let's dive in to the material. So I'm looking at this reading material titled The Initial Pleading, Chapter 2. Structurally in the course, here's the attendance sheet if you want to sign that. Structurally in the course, remember, we've done an introduction, kind of a sense of good legal writing, some of the principles that are at play. We looked at the Osbeck piece. We looked at this public law from Congress about the Plain Writing Act. We also looked at a philosophy of drafting. And then we kind of moved on into the world of civil litigation. And we started last class, or spent most of last class, by looking at this general introduction to litigation-related documents. We talked about kind of the whole scope of litigation, complaints, answers, motions to dismiss, motions for summary judgment, some of the discovery-related motions and documents that you might have to consider during the course of litigating a civil case. We're going to spend today really kind of dissecting the aspects and the components of a complaint, which is thought of as the initial pleading. So let's begin by thinking about the purpose of the initial pleading. I mean, we're in the world of lawsuits, civil litigation, and the question is, let's see, Joe. Well, the question I have, Joe, is what is the purpose of an initial pleading?
It's supposed to notify the defendant of a potential claim against him or her and the relief side.
Yeah, so you're giving notice to the plaintiff. You're saying, hey, this is a civil case. We're filing a lawsuit against you. This is what it's about, and this is the relief that we're seeking, right? It's going to allow the defendant to then turn around and file some sort of responsive pleading in court. And the reading material kind of makes it clear that due process demands that a plaintiff file an initial pleading if they're going to kick off a case. It's funny, today I had kind of an odd thing come up where somebody wanted something from the clerk's office, and it was really not clear what this litigant wanted, and so the clerk's office called me up and said, what should we do about it? And I said, well, why don't you just, if you're not clear, why don't you just ask the person in writing, or to put the request in writing? And the person really didn't like that, and like started lashing out at the clerk's office, and then the marshals got involved. But I was reading this again today, and I thought to myself, you know, putting things in writing is what it's all about in state and federal court, right? I mean, that's when the parties can kind of the parties in the court can kind of know what's going on procedurally. We don't just call people up and say, hey, I'm suing you, so let's meet in state court. No, you file a document with the court, and then you have to issue summons and send a copy of the complaint to the defendant. It prevents them from being unfairly surprised by what you're alleging. Now, the real thing here is, what do you need in court? What do you actually have to put forward in order to kind of properly notify the defendant about the nature of your claim and the type of relief you're seeking? I mean, you could imagine it being like a Post-it note saying, hey, you're being sued for negligence, Kroger, we're not going to tell you what it's about, but you're being sued for negligence, here's your postcard, we'll see you in court. I mean, is that enough? What do you need when we're thinking about this second part, Joe? How do you draft a legally sufficient pleading? I mean, we'll talk about the ins and outs of what exactly you need in a complaint, but generally, kind of what are you going to have to include if you're a plaintiff who's thinking about filing a complaint, let's say in federal court?
It's got to be allegations sufficient to show an existence of a claim. So
yeah,
I guess you look to Iqbal and Twombly.
Yeah, for sure. I mean, we're definitely going to get there. I mean, you start with this idea of legal sufficiency, which is just what I think you need to be having in mind is, look, if I'm a plaintiff, I'm filing a lawsuit, I'm alleging some wrong occurred. The defendant ran afoul of something, right? Some rights that I had, or I have a claim, and that claim almost always is going to require me to prove a specific set of elements. That's also known as a cause of action, right? So if we think about torts, right, we think about duty, breach, causation, and damages, right? So if you're a plaintiff who thinks you have a negligence claim, you've got to allege enough facts that go to each of those elements of the cause of action of negligence, right? But it would be true if it was a contract case, right? You would have to first think as a lawyer drafting a complaint on behalf of a client, a plaintiff, what are the elements of contract law, right? I mean, does anybody like contracts? Wasn't my favorite. But we know enough to know, like, you have to have the existence of an offer, right? An offer, and then the other party has to accept the offer. And there has to be typically consideration, right? This for that. And then a breach of the contract, right? Offer, acceptance, consideration under Article 9 of the UCC. That's going to get you the contract. And then if you've suffered some damages, you've got to say that they breached the contract. And here's the damages I'm seeking, right? Expectation or reliance, restitution, all of those forms of damages, right? Some of that's right. Yeah, you would plead those things. Now, you could imagine maybe just writing something that sounded real legalistic like that, like, oh, I'll cite Article 9 and they'll think I'm smart. But the question is, like, is that what a complaint is about? No. It's about you in the background as a lawyer recognizing what you need to prove. But when pen comes to paper, some of that may make its way in kind of as a framework for what your claim is, but what you're really alleging are the factual allegations, right? So if we go back to the torts negligence hypothetical, if you're in that world of like the slip and fall at Kroger on 3rd Street, right? You're thinking about duty, you're thinking about breach, you're thinking about causation, and you're thinking about damages. But more important than saying those words, you're thinking about what facts exist in my case file that go to duty, what do you need factually to prove up the existence of a duty, right? Well, you probably need something about the nature of the relationship between the parties, like Kroger owns a restaurant, or Kroger owns a grocery store on this street in Louisville, Kentucky. The plaintiff was a customer. And why would that be relevant? Well, that goes to the nature of the relationships between the parties, right? And you would have to know somewhere in the back of your mind or out there in Westlaw or Lexis that grocery stores owe customers a duty of care. I mean, maybe they don't, in which case you're going to have a pretty bad negligence claim. But they probably do, right? That sounds right. And so you're thinking about the cause of action, you're thinking about the elements of a cause of action, but you're also thinking, more importantly, as it says in the bottom of page 14, you have to set out in the pleading allegations sufficient to show the existence of a claim, or what they call a cause of action. And why is that? That's because you want to avoid a motion to dismiss, right? I mean, ultimately, if you do not allege enough facts to go to each of the elements of the cause of action of, say, negligence, the defendant is going to come back with a responsive pleading known as a motion to dismiss. A motion to dismiss for failure to state a claim upon which relief may be granted. They're going to say, hey, even if what you're saying is true here, the court ought to dismiss this complaint because the plaintiff has not proven has not alleged facts to go to each of the elements of the cause of action, right? So you might have duty and breach and causation, but if you didn't suffer any damages, you don't win, right? Because you need duty, breach, causation, and damages. You need all four, right? So you've got to be thinking about factual allegations. That's what complaints are all about, alleging enough facts. Now, Joe is right. When we think about these standards in federal court, you don't have to knock your socks off with this. I mean, we could have like a bunch of nerdy fun and get into like Twombly and Iqbal and let's all be dorks together. Like, I like that stuff. You probably like, maybe when you're in law school, so we're all kind of nerdy, right? And that's cool. But like, this isn't advanced civil procedure here, right? We're not trying to like outline Twombly and Iqbal, right? All we have to kind of know is that we've got Rule 8 here, right? We've got Rule 8, which says that you've got to have a short and plain statement of the claim showing that the pleader is entitled to relief. The question is, how much detail do you have to have? And we used to have the Conley rule, we used to have notice pleading, and now we think more about this Twombly-Iqbal standard of plausibility, right? The court held that a complaint should survive a motion to dismiss for failure to state a claim only if the pleading contains sufficient factual matter accepted by the court as true to state a claim for relief that's plausible on its face. And so you get this two-part standard, this plausibility standard. I honestly think at the end of the day, and state courts have some of the same standards, these notice standards some courts follow a plausibility standard. I think what you guys have to be thinking of is kind of like fact pleading, right? And what does that mean? Look at this material on page 17. It says, some states require the pleading of some facts in order for a complaint to be legally sufficient. Many fact pleading jurisdictions require the pleading of facts sufficient to state a cause of action. And then what does it say? Stating a cause of action typically means the pleader must allege facts to support each element of at least one cause of action. Standards for stating a cause of action might or might not require significantly more detail than pleading under a notice pleading plausibility standard. For our purposes, what you need to be thinking about is, what are the elements of my cause of action? Contract law, tort law, wrongful termination, right? Employment discrimination, Eighth Amendment deliberate indifference, whatever type of case you have, right? First Amendment, RFRA, something ERISA, whatever it is, you got to figure out, one, what are the elements of my cause of action? Now, fortunately for you guys in this class, I tend to give that to you, right? Because it is a drafting class. Like, I don't care if I care, but I'm not testing you on like, oh, I hope you go out there and do a bunch of legal research and get the exact right elements of that cause of action. No, like, I'll give it to you. I'll be like, here, spoon feed, open up, here it comes, negligence law, and you'll get that. So it's not a question of what are my elements in this class, you'll get those. The question is, can you then take your case file and draft enough facts to meet each of the elements that you need to meet in order to sufficiently plead a cause of action for whatever, okay? Any questions about that? See, it's kind of boring today, but it's also complaints. This is the least kind of, fun part of the class here, complaints. These are also the most technical form of documents we're gonna draft, right? Because they're not like, oh, bottom line up front, proof like writing, which is like my whole world. That's what I live for. I mean, it's sad. It's a sad existence. But that's what I love. This is like the technical stuff. This answers technical, but we've got to get through it. Procedural matters. Let's go to Mitchell. What about these procedural matters addressed in the pleading? What are some of the procedural things you want to be thinking about? So now we know we're thinking about our cause of action, the elements of the cause of action, and we're thinking about alleging facts that go to each of the elements. Beyond that, what are some of the other things you need to be thinking about, Mitchell, in drafting a complaint?
He's not here.
Oh, so I'm talking to nobody. Okay, that's really great. Alex, that's you, sorry.
Jurisdiction.
Okay, pleading jurisdiction. Now, what are we talking about with respect to jurisdiction?
Well, subject matter, personal.
Yeah, subject matter and personal. Okay, well, what about subject matter? Put your Civ Pro 1 hat on, right? What are you talking about? We're at, let's say, federal court. You're in federal court. How does a federal court have subject matter jurisdiction over a case?
If it's a federal question or if it's diversity of citizenship.
Yeah, good, right? Good. So when that's on the bar exam, you got it, right? Federal question, arising under jurisdiction. Arising under, for 6 months when I was a 1L, I was like, arising under what? Arising under federal law, right? If the case arises under federal law, it's a you've got federal question jurisdiction. So it could be like a federal statute, right? The source of your claim is a federal statute, right? That's not true in torts, right? What's the source of tort law? Anybody know? State law, common law. Yeah, it's state common law, right? I mean, there's no state tort code. It's state law that's common law, right? Federal law is different, right? You're talking about federal statutes or federal constitutional law, right? The Eighth Amendment deliberate indifference cases that I see all the time. Hey, I'm in my federal prison and they're not giving me my insulin, and so that's cruel and unusual punishment in violation of the Eighth Amendment. That case arises under federal law. So that's one basis for jurisdiction. The other, of course, is diversity of citizenship, which requires a plaintiff and the defendant to be of different states, residents of different states, and then the amount of controversy has to exceed $75,000. Not exactly $75,000, right? Because there's that famous, have you heard about the Penny case? Yeah, the famous Penny case where it was exactly $75,000, and it went, nobody knew, everybody kind of just glossed over it, went all the way up to the Court of Appeals. And the judge, sua sponte, dismissed the case and then wrote a whole opinion about how, people leave pennies on the floor and nobody bothers to pick them up. But this was the case where the penny had its moment. And I'm like, this is not cool. Like, let's move on to the next thing, right? Okay, you wrote a whole opinion about a penny. Great. Made the case book, though, so great. Okay, so that's pleading subject matter jurisdiction. We're thinking about, in federal court, of course, diversity of citizenship and arising under jurisdiction. And so you look on page 18, and you can see, okay, that's what so now you're thinking about this as something I need to include in my complaint, right? I mean, we'll talk about technically where you would put it and all of that. You'll see examples of that in some of the case files. But you've got it, that's something you're going to want to include, right? And so if you look on page 18 in this first box, if you've got diversity jurisdiction, you might say something like, look, plaintiff is a citizen of the state of Illinois, a resident of Cook County. Defendant is a corporation incorporated under the laws of Delaware, where its principal place of business is Florida. So you're thinking, well, there's some diversity going on there. And then the court has jurisdiction pursuant to 28 U.S.C. 1331. The parties are diverse. The plaintiff seeks in excess of $75,000 in damages. And whether you really need the citation there, I don't know that you technically need that. But we'll talk about the extent to which you want to include maybe legal authority in your complaint, because really, the whole game here is making sure you're alleging facts to prove the existence of jurisdiction. Or you can see the next box, right, pleading the basis of federal question jurisdiction. The action is for trademark infringement and unfair competition under 15 U.S.C. 1125A, and for cyber piracy under piracy. Sounds like, oh, we're on a ship. 15 U.S.C. 1125D. But those are statutes, federal statutes, under which the plaintiff is bringing his or her claim, right? So that's something you really want to be thinking about. Personal jurisdiction is a little bit different, right? Courts kind of differ, and you'll be on notice whether it's something that you have to include, but courts oftentimes differ on whether you kind of have to clearly plead personal jurisdiction, but you know the basis for personal jurisdiction, right? A state court has personal jurisdiction over an individual who's domiciled in the state, or a corporation that's incorporated in the state. What if you're a non-resident defendant? How do you have personal jurisdiction over a non-resident defendant? Yeah.
Long-arm statute and due process.
Yeah, long-arm statutes, right? You learned about that in CIPRO 1. Due process, that's that whole body of case law. Pennoyer, bye-bye. International shoe, minimum contacts, and then all of the cases that came after that. Again, this is not, we're not, if you didn't like worldwide Volkswagen and all those things, this is don't run away. We're not doing all that in here, right? The point here is, in drafting a complaint, you're thinking about, you've got to include allegations with respect to subject matter jurisdiction. You may or may not want to include them with respect to personal jurisdiction. This class is not about personal jurisdiction. It's about what do you need. One of the things it's about is what do you need to draft a legally sufficient complaint, right? And so you're thinking subject matter jurisdiction for sure, maybe personal jurisdiction you're going to have to allege. Venue, what about venue? Alex, what do you think about venue? Do the federal rules of civil procedure require you to plead venue? No, good. Yeah, 50-50. I mean, what if you would have said yes? Nothing would have happened. No, they don't. So generally, they don't require it. If you did want to include it, though, you would look on page 21. Venue is proper in this jurisdiction under 28 U.S.C. 1391A2. Now that's just legal, though. That's not where it's at. Where it's at is a substantial part of the events giving rise to the claims occurred in this district, and all parties reside in the state of Colorado, right? And then there's pleading special matters, but if you had to plead a special matter like fraud or mistake or satisfaction of a condition preceding, I would tell you about that, okay? And then let's talk about two more things, and then we'll kind of tie all this together. Demand for judgment. What is a demand for judgment? Alex. What is a demand for judgment? Where does that go? Prayer for relief.
Probably at the end.
Probably at the end, that's true. And what is it? What is a ad damnum clause? A demand for judgment. What is this?
Is it a request for relief?
Yeah, and what in a torts case, let's say, what might you be requesting?
Damages?
What kind of damages?
Compensatory and punitive?
Yeah, monetary damages, right? Compensatory damages, punitive damages. What other form of damages might you be seeking? Injunctive relief, right? Hey, I want you to do this, or order the prison officials to give me my insulin, right? Order the defendant to move his fence, to tear down his fence off my property, right? Declaratory relief, declare the rights of one party or another, right? But this is something that you're going to include in your complaint, because the rules of at least the federal rules of civil procedure require that a pleading for affirmative relief include a demand for the relief sought, right? It says the clauses are generally introduced by the word wherefore. One of my tests, this may go back to good legal writing. If you don't use it in your, vernacular, if you, in talking to a buddy of yours, maybe that's too informal. But if you don't just use it every day, I wouldn't use it in your writing. Do you say wherefore? No, probably not. I mean, maybe I do, but be cooler than me, right? Which is a low standard, right? And shockingly low. But wherefore, I wouldn't use it. Just say accordingly. And then maybe you don't say that out loud, but accordingly is more. Therefore, in conclusion, in short, as a result, ultimately, right? Heretofore, you don't use heretofore, right? I think that makes for better legal writing if you just kind of make it a little more conversational, I think. I don't think there's anything wrong with making your writing. I think you should try to make your writing more digestible. That's just a note on that. Wherefore. And then exhibits to pleading, Rule 10C says if you include an attachment to your pleading, that's considered part of the pleading for all purposes. Just a side note, nothing too specific to know. So what have we talked about so far? Well, we've talked about, one, the purpose of the pleading. You know that, right? It's to say, hey, I'm suing your ass, right, in court, in federal court. I'm giving you notice. Here's what my allegations are. And you, as a due process kind of right, have a sense of what I'm alleging and what sort of relief I'm seeking. That's background. Then you're thinking about drafting a legally sufficient complaint. What you're really thinking about are two things, I think, at this point. One is, there are some things you're going to need to include in your complaint, like pleading subject matter. You're going to need a caption, and we're going to get to that too. You're going to need things like a caption. You're going to need procedural things, like, hey, I'm going to plead subject matter jurisdiction. I may want to think about personal jurisdiction. I maybe want to think about venue. Beyond that, though, beyond those few little procedural things here and there, what you're really thinking about is what we talked about, which is pleading enough facts. Don't worry about, oh, is it Iqbal, is it Twombly, is it this? We're thinking about what are the elements of my cause of action, and have I alleged enough facts to go to each of the elements of the cause of action, okay? So that's background. Now, we're going to move to thinking about more specifically the fundamentals of drafting a complaint. Okay, you're thinking these are the things in my brain that I'm going to need to include in a complaint. Now let's think about how do you actually structure it, okay? So, how about Hannah? Fundamentals of drafting a complaint. What about this format and presentation requirements? Well, it starts out by saying, look, you've got to look at your local rules. Okay, well, I'll give you some local rules that you're going to have to follow in reviewing a case file. But what about, Hannah, identifying and referring to the parties? How do you want to identify and refer to the parties, and where do you do that?
You start with what the reading calls commencement. So you're identifying the plaintiff suing the defendant, and then that's, if you have multiple parties, you identify how they're going to be referred to throughout the complaint, so you don't mix up which parties which.
Yeah, I mean, we're starting out at the beginning of your complaint by saying something like what's in this box on page 24. Plaintiff Jordan Smith sues defendants Mark Reed, SNZ of Florida Convenience Stores, and Hogtown Machinery. What's going on down in Florida? And alleges the following. That's good. I'm never a fan of, like, Plaintiff Colin Schuler, heretofore known as Schuler, in quotes, files a civil lawsuit, just a lawsuit, or alleges, sues, defendant Kroger Corporation, also known as Procter & Gamble, doing businesses. Try to just make it simple. Like, only put what you need. All that verbiage. It would be great if you could say, Plaintiff Colin Schuler sues defendant Kroger, Inc., and a comma, and alleges. Because if you then later start referring to Schuler, there's only one Schuler. You don't have to say, heretofore thereafter known as Schuler. It's just verbiage, right? And if you go back to these principles on good legal writing, you want to avoid that kind of verbiage, that legalistic language, right? But you do want a commencement clause, something at the beginning saying, hey, here's the plaintiff, that person's suing this individual or this corporation, this defendant, and the plaintiff is alleging the following facts, right? Now, what are the different types of allegations? This is where I think it gets a little bit more, not critical, but it's a little bit more tangible, something to think about. What are the 4 types of allegations? Right?
Same or sequence?
Yeah, sorry.
Just want to make
Yeah.
sure. So there's.
I could go back to Mitchell. Who's that? Mitchell, what are they? Sorry.
There's a legal conclusion, ultimate fact, evidentiary fact, and extraneous detail.
Okay, let's walk through these, Hannah. What is a legal conclusion?
It's the pleader's opinion about how the law operates or how it should operate.
Okay, well, what is that?
Um,
Give me one. Give me one. Give me a legal conclusion. Just let's make it up.
that the defendant owed a plaintiff a duty of care.
Yeah, that's a legal conclusion. The defendant owed the plaintiff a duty of care, right? You're concluding as a legal matter, right? The defendant owed the plaintiff a duty of care, or the plaintiff and the defendant entered into a contract. That's a legal conclusion. Or the seller of a home offered to sell her home to the alleged buyer. Those are all legal conclusions, right? They're not facts, right? You're not alleging any facts that prove up that legal conclusion. What is that? What are those facts called?
Ultimate fact.
Ultimate facts. And this is like the key thing you need to know. I mean, it sounds like it's like on the test, there's no test, right? But I mean, the thing you kind of need to be thinking about are ultimate facts. An ultimate fact is a fact that's necessary to establish an element of a cause of action. Your complaint ought to include a lot of ultimate facts. Facts that are needed to establish an element of the cause of action. So if you had like a complaint, right, and if you were thinking about the whole negligence one, you might have something like, in the county of, or in like Fayette County, or where are we, Jefferson County? Jefferson County Circuit Court, right? And then you might have like plaintiff, Colin Schuler versus defendant, Kroger, Inc. And then it's like, I hate that. And then it's like case number, whatever, 1, 2, 3, Judge Judy. And then it's complaint. And then it's the commencement language is here. You could see, like, plaintiff Colin Schuler sues defendant Kroger Incorporated and alleges the following, Colin. And then you're going to have numbered allegations. You could imagine drafting a complaint that's saying, Kroger owed Colin a duty of care. Oh, okay. What? Who? What's the story? Right? Who is Colin? Right? You might start out by thinking about some of these procedural things like subject matter jurisdiction and personal jurisdiction. But quickly you're going to want to be like kind of introduce the party. Like Colin Schuler is a resident of Fayette County, Kentucky, and is a citizen of the state of Kentucky. Kroger Corporation does business in whatever, and they're a citizen of wherever, and the amount of controversy is this. Let's say they're a citizen of whatever, Delaware, and they are doing business in Kentucky, and it's more than 75,000, so there's diversity jurisdiction. And you're quickly getting to the allegations. And the first thing you're thinking about is duty of care. As a lawyer drafting a complaint, you're thinking about duty of care. But instead of alleging the ultimate or the legal conclusion that the defendant owed the plaintiff a duty of care, you really want to be alleging a fact, an ultimate fact that's necessary to establish that element of duty. So in my example, what would be an example of an ultimate fact to show that the defendant owed the plaintiff a duty of care? Hannah. I've kind of already said this, but.
That the plaintiff, like, so Colin was a customer at Kroger on such and such.
Yeah. And then the next allegation, numbered allegation, might be like Kroger runs it might have been Kroger runs a grocery store at this address. Colin was new allegation. Colin was a customer at this address. Just like in the reading material, it says the defendant owned and was driving the car. Now you might think, well, owned and was driving the car, that doesn't establish anything, but really under the law, owning and driving a car is you owe duties to other people on the road, right? I mean, if you own business, you owe duties of care. If you own land, you might owe duties of care depending on who comes on your land. Invitees, licensees, trespassers, right? There's always, it's almost like you almost want your reader or demand that your reader kind of know a little bit about the law. They're not very important. It's not like course class where you're like, come to legal conclusions. It's really all just facts here, right? Like a sophisticated reader might be like, oh, there's duty, oh, there's breach, oh, there's causation, but really all that's being alleged, all that's critically being alleged are facts, ultimate facts, facts that you need to allege in order to prove up that element. Now, you don't want to include, I mean, does that make sense? I'm kind of like all over the place here. Is this, it sounds boring, but that's where it's at with complaints. Now, let's talk about this. What, Hannah, do you think would be the benefit of something including legal conclusions?
It would help you see where the defendant's mind is at with regards to some of the allegations. I know that's in the
No,
legal
tease that out. What do you mean by that?
Because you might, I mean, some of them might be willing to admit to some of the legal conclusions in your complaint, so you wouldn't have to take as much to court.
That's possible, right? They might admit a legal conclusion and then you could kind of avoid litigating that issue. What else could it do? Maybe for your own benefit, but also for the benefit of the reader. I think more for your own benefit. It's kind of like an Alan. Yeah, tell me your name again. Anthony, what do you think?
Be more persuasive.
Well, that's an interesting thing you say, Anthony, because I think that's right. I think you're right about that. The real thing, though, Anthony, is like, I don't know that the point of the complaint is to be persuasive. I think the point of the complaint is to really try to put the defendant on notice about what they're being sued for, what sort of relief you're seeking, right? But also that you can kind of glean information from the defendant, right? Because ultimately you want them to admit or deny factual allegations. Like you want them to admit or deny that they operate a grocery store. And that may be easy, they'll admit that. They may admit that you were a customer at the grocery store, your client was a customer. But are they gonna admit that there was a banana peel there, right? Are they gonna admit that, you know, it was a poorly lit hallway? Are they gonna admit in this Porsche pond drafting exercise you guys are gonna have to do, are they gonna admit that there was a 5-gallon drum leaking jewelry fluid onto the floor? I think that's what you wanna do, so I think it's less about persuasion, but I do think it's kind of about orienting yourself, right? It's about like framing the complaint. You ultimately want to get information from the defendant in the form of admissions or denials, which can be informative, like, oh, they're contesting these issues, right? You ultimately want to see what are they going to admit to, what are they going to deny factually, but I think it's like a lot of things. It's like writing an outline in law school. Like, it might help you to orient yourself and have little headings kind of like, you know, duty of care. And then it's kind of clear which of these factual elements go to duty, right? Now they may not admit this, they may deny it, or they may not even address it because it's a heading, but it does kind of orient you like, oh, these are the elements, these are the factual allegations that I'm alleging that go to this cause of action, this element of the cause of action. And you could do it in headings. You could also start out a section, or you could have, like at the beginning, you could say, the defendant owed the plaintiff a duty of care. Now that's going to be kind of dismissed by the court. They're not going to be thinking about that. They're not going to, that's not what they're looking at. The defendant doesn't have to admit or deny that. But it does, and they may almost always deny it because it's a legal conclusion. But at least it puts it out there and frames the complaint in a way that maybe Anthony on some level is right, that it is kind of persuasive, but it's persuasive in the sense that it's organized. It's a good structured complaint. So I guess what I'm saying is I'm not one who says don't include any legal conclusions in your complaint. I think they function as a way of organizing. It's beneficial to the plaintiff in the sense that it helps you as an attorney, plaintiff's attorney, organize your allegations, right? Like, I don't know, like let's say you had a to-do list and you were like, okay, I've got to clean my room. I sound like my 8-year-old daughter. I've got, let's say you have 3 rooms you've got to clean. Bedroom, bathroom, and kitchen. Now you could just have a to-do list that's like make bed, take out garbage, clean toilet, wipe down sink, clean bathtub, empty dishwasher. You could do it that way. Or you could have like A, bedroom. 1, clean, make bed. 2, empty trash. 3, I'm trying to think of all the things she better have done before I get home, right? Clean out little tent that she has a teepee tent that's like, fun. And she like her hideout and she sits in there, but it always has trash in there. I'm like, take this out, put Harry Potter books away. And then B might be like bathroom, right? Like make sure sister's little potty is cleaned out so that when I walk in there it doesn't smell like urine, right? 2, wipe down sink. So it structures it like, oh, these are the rooms I need to clean. Do you need those like headings? No, but it organizes it. And I think similarly, if you've got headings like duty, breach, causation, damages, it structures your complaint. It'll be a lot easier, I think, for you to draft if you've got those things in there. I like headings. You might like just like transition sentences where the legal conclusions exist. I wouldn't say it's all about persuasion, but I would say it's about making sure you've got what you need. It's like a skeleton, making sure you've got what you need so that you don't miss an allegation that you need. Because if you miss an allegation you need, then you run the risk of having a 12b6 motion come in your face, okay? So legal conclusions are things that the courts are generally going to disregard, but I think they serve an important function of helping you frame your elements, right? Ultimate facts, though, are what you need. And that's what are necessary to establish each of the elements of the cause of action. Evidentiary facts are interesting. Those are facts that basically help you or provide support for the existence of an ultimate fact. So if the ultimate fact is the defendant owned and was driving the car, that helps prove the existence of the duty. But you might think of what evidence do I have that the defendant owned the car? Well, their name was on the title of the car. But what's interesting is you don't need evidentiary facts. You don't need to prove the ultimate facts. You just need to allege the ultimate facts. Because the court's going to look at it and say, if I assume all of these things are true, the defendant owns the car, the defendant was driving 800 miles an hour in a 25, the defendant flipped over and landed on the plaintiff's car, and the plaintiff was left, God forbid, in a wheelchair, right? I mean, that's duty, breach, causation, damages without saying it. But you could have had good headings about duty, owned the car, breach, drove 800 miles an hour in a 25. Drove 800 miles an hour. It was a 25. Causation, blah, 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 blah. Damages, the plaintiff, God forbid, was left in a wheelchair and had 6 surgeries and has a feeding tube. I mean, awful stuff. Suffered all these damages, right? That's how you could do it too. Extraneous details, those are just extra things that the authors say take up space on a page. I think if you're thinking about evidentiary facts, if you're thinking about extraneous details, and if you're thinking about legal conclusions, it's not that they can never be useful. It's just that that's not what's doing the work for you in a formal way, right? Functionally, they may serve as guideposts or organizations or let you kind of follow the story yourself to some extent. But at the end of the day, it's about you alleging ultimate facts, enough ultimate facts to prove up each of the elements of the cause of action, okay? Because it's getting exceedingly boring for you, I think we can take a break for a few minutes. Let's take a 5-minute break till 7:50. Maybe that's a 7-minute break. And then we'll kind of continue on with some of this stuff with respect to ultimate facts. Is it 7:45, or did I just make that? Yeah, that's right. Let's go to 7:50, so 6 minutes.
I was gonna give you this, that I took this to my boss today.
Yeah.
He said, oh, I just wanna play the sets. Attorney play.
A lot of jargons going on.
Yeah, we always do this, comes out of those.
Yeah, I need to go get that.
They say this is legal jargon, instead of Rush, it's like, that's interesting.
I feel like that's what happens with people, is they just fall into a pattern and it's
Well, I
just-
have, been using
Yeah.
the same forms, I'm
Templates.
using his forms,
Yeah.
and so it just,
Yeah,
whatever it
copy and
says,
paste.
right, yeah. But I appreciated that.
Oh, gosh, yeah, well, that's something.
Someone really messed up this door.
Yeah. It's been like that since finals last semester.
Really?
Mm-hmm. I wonder if someone just got pissed enough that they signed it.
I feel like it never recurs right over it. Oh, yeah. Can you collect everyone's names from us? Okay, they're just up there.
Get it printed.
Mhm.
Thanks, man. Have they put out the schedule for next
Yeah.
fall? Yeah. Do you know when, they have? Oh, do you know when that?
I don't know if it's final, they put out a draft,
Yeah.
do I know when what?
Oh, well, I was gonna say, do you know when they're gonna put it out, but it sounds like they did. When do you all register?
That's a great question, cause I'm
I'm doing
graduating,
it,
so
so I don't care.
Is the schedule they posted electronic?
Yeah.
Yeah.
So it's on the, like, the website where you do the drop down and it says
Yeah.
fall 2020?
Yeah, yeah, yeah.
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 I wasn't sure if they had done that. Cool. Oh, I don't care, that's fine. I mean, you'll lose all your points. Right? Just script it, no, it's fine.
It's only like a deal.
I mean, it's just, that's it. Yeah, it's medical. All right, I'll try to get out a few minutes early, hopefully. All right, so let's continue. So we're talking about these different types of allegations. We've kind of already touched on this. The next section is use of types of allegations in a pleading. So use of ultimate facts and use of legal conclusions, and then evidentiary facts and extraneous details. The bottom line, I think, it's what's captured on the bottom of, if you look on page 25, where it says use of ultimate facts. I think it's this last line, or last few lines. Matching facts to elements whenever possible makes it clear, thanks guys. Matching facts to elements whenever possible makes it clear that the complaint states a claim. I mean, it sounds so simple, but if you have a sense of, hey, this is what I've got to prove legally in my complaint, 1, 2, 3, and 4, you want to think, what ultimate facts go to this? I need to allege those. Which ultimate facts go to this? I need to allege those. Which ultimate facts go to this? I need to allege those, right? They say, unless your state requires otherwise, which it won't in our class, we recommend that you support each element of the cause of action with ultimate facts. Those facts that are necessary to establish that element. And I think this idea of legal conclusions as a framework, that's what comes here from this Iqbal site. It says in Iqbal, the Supreme Court said that legal conclusions can provide the framework of a complaint if the conclusions are supported by factual allegations. So you don't have to discount legal conclusions. I think where you get into trouble as a lawyer, and I've seen this a lot, are lawyers who, it's all about the legal conclusions. It's all about, I'm going to make this super persuasive to the court, but you run the risk of not including enough factual allegations and thus potentially facing a 12b6 motion to dismiss, okay? Let's talk about framing the allegations. Kirby, let's talk about this. What do you want to think about with respect to framing your allegations? So we know you need to include factual allegations that go to each of the elements of the cause of action. How do you want to draft those factual allegations?
Clearly and concisely.
Yeah, I mean, this really just goes to the idea of good legal writing, right? Plain, concise, direct, no more words than necessary to make the point, right? No legalistic language, right? When you're actually drafting your sentences, try to follow the various principles that we talked about with respect to good legal writing. You also want to focus on the parties, right? A pleading is a story about a relationship between the parties. I mean, really, it's just, that's all it is, right? Colin Schuler is a resident of this state, blah, 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 blah. He went into the Kroger on this date. He slipped on a banana peel. He fell down. He hurt his back, right? I mean, look at these allegations on the, you want to paint a picture. Use active voice. Look at the allegations on page 27. On or about May 10, 2012, defendant Carr failed to provide plaintiff with a written estimate of repair costs. On that date, defendant Alford or defendant Bailey failed to comply with the vehicle inspection requirements. By their actions, defendants violated the statute. Now that's interesting. You got a couple of factual allegations that I would say are kind of about ultimate facts there, and then you've got what looks like a legal conclusion. But I think the legal conclusion's serving a function. It's like, okay, because I said this and this, I've proven this. There's nothing wrong with that if it kind of keeps the story going, right? Alleging time and place, right? There's not specific hard and fast rules on this, right? I mean, you want to make sure that you're alleging or you're putting forth allegations regarding time and place that are material, and they recommend that you put those at the beginning of the sentence. I think you want to put them where they're relevant, right? One pet peeve of mine is alleging dates where they're not needed. Some people feel the need, it's like, well, on February 3rd, it was the Iowa caucus, and on February 4th was the, nothing. And then I, got coffee on February 6th. It's like, well, was that relevant? Was the time relevant to the allegation? If not, then I don't think it's something that you need. Don't be afraid to just not date everything, right? Oftentimes, students, I think attorneys as well, have this tendency to kind of put a date on everything when they don't need to. I think number 4 is the most important. One of the most important parts, Kirby, of this whole thing. And why is that? What is this about pleading strategically. It says framing allegations to elicit admissions. Talk to me about this. What is going on here? Because I think this is arguably the most important part of the entire material.
This is what it talks about. You have to predict how your question is going to, like, what kind of doors they open for the defendant to answer. Are they going to be able, is it going to force, can you, like, kind of force them to admit or deny something? So it's good to be more objective and neutral instead of, like, conclusory order as objective, because then they're just going to deny it. But if you just say that there was water on the floor versus saying the defendant spilled this and there's water over the floor, so it's easier, and they're going to have to admit that did happen.
Yeah, I think yes, I think you're right there. I mean, I think the idea of saying the defendant spilled something, that may just be a neutral fact, right? Somebody either did or didn't spill something. But I think negligently did something. The thing is, what you want to avoid in alleging ultimate facts is you want to avoid inextricably intertwining your factual allegations with legal conclusions. This is Anthony's point, I think, that we need to emphasize, which is when you're trying to make an argument about a case like negligence, you want to kind of put some force behind legal conclusions, right? If I'm like two people come up here, Anthony and Kirby get up here and argue about whether or not Kroger was negligent in this fact pattern. You're going to both have language like it was negligent, there was a duty owed, there was a breach, there was causation, there were damages. Look, he was negligent in leaving this banana peel here, and oh well, but he assumed the risk by doing this. And if you're arguing it, if you're trying to kind of make a persuasive case to win the case, you will often bring legal claims, legal conclusions to bear in a complaint, in an argument, right? But what you've got to realize is that's loaded language. Those terms, those legal kind of conclusory terms, are loaded language that defendants are going to just deny. Oftentimes, not always, but a lot of times defendants will just deny those allegations because they're really not allegations, right? And so the minute you start injecting what is otherwise a really good sentence about ultimate facts, the minute you start injecting that sentence with inflammatory, let's say, legal conclusions, you run the risk of losing any ability to get the defendant to admit those allegations. They're just going to deny them, right? If I said there was a banana peel on aisle 6, laying on a banana peel was laying on the floor in aisle 6, that's pretty neutral. There was either a banana peel or there wasn't. If they admit it, they're saying, yep, there was a banana peel. If they deny it, they're saying there was not a banana peel. It's like yes or no. Did you clean your room? You did not clean your room. And my daughter will be like, yes or no. My daughter's smart. She's an 8, but she's going on like 28. She's the most like outgoing kid. She'll be governor, I swear. She's like working the room. The other one is like, leave me alone, F all you. She wants none of anybody. I've got the yin and the yang going on at home. But yeah, like you pin people down. You're admitting it or you're denying it, and that's it. But the minute I'm like, well, your room was sloppy. Sophia left her room in a sloppy way. No, I didn't. Deny. Right? What's sloppy mean? What's negligently mean? When's a duty of care owed? Right? The minute you start using those terms, you really run the risk of people just denying them. So Kirby's right. Although that may not be the most persuasive thing, right? I mean, it's persuasive to be like, it was sloppy. It was obstruction. It was whatever. Here's a legal conclusion. Isn't it more, that might make for a good argument or a passionate claim. But in a complaint, you're trying to kind of draw out information from the defendant with the goal of really narrowing the case down to its bare bones and proving as much as you can. And the way to do that most effectively is to take the passion and the legal conclusions out of it and just allege things in a very neutral way. On January 12th, 2020, Colin walked into Kroger on 3rd Street, period. I either did or I didn't, right? Colin walked over to the banana aisle, period. I either did or I didn't. Colin slipped and fell on a banana peel. I either did or I didn't, right? Or there was a banana peel on the floor first, period. Colin negligently, don't go that route. Colin slipped and fell. You would just allege neutral ultimate facts, right? And this is what they're focused on here. Page 29, second paragraph. To get meaningful responses from a defendant, frame allegations of ultimate fact neutrally, objectively, and with precision. A neutrally framed allegation set out the facts free of the drafter's conclusions, arguments, beliefs, and factual inferences. An objective allegation is one that focuses on the observable facts instead of what the party subjectively perceived or concluded. A precise allegation is one that sufficiently identifies the key issues of who, when, what, and where. And so Kirby's right, this allegation, a conclusory one, is on or about June 9th, 2012. Defendant negligently failed to remove spilled water. And they're going to be like, no, we didn't. We didn't negligently fail to remove anything. Neutral, on or about June 9th, 2012, there was water or some other liquid on the floor. I mean, there either was or what. If there was water there or liquid, what are you going to do as a defendant? Put yourself in the defendant's shoes. Think strategically. What's the defendant going to say, right? If they're going to be like, can they weasel out of it? Can they weasel out of your factual allegations somehow? Now, that's not to say that you only want to include allegations that they're going to admit to. They may deny that there was a banana. It wasn't a banana peel. Maybe they deny that, and maybe that's what your case is about. It's all about, was there a banana? Oh, it was a gum wrapper. Oh, shit. You shouldn't have had gum wrappers on the floor either. I mean, maybe that's what it becomes about. So it doesn't mean that you have to only include allegations that you know they're going to admit, right? Because there's questions of fact that are contested all the time. But you don't want to miss out on an opportunity to get them to admit critical facts because you injected unnecessarily legal conclusions. Now, maybe you're willing to include legal, or maybe you want to. Remember, go back to this idea of, I want to frame my complaint and include legal conclusions so that I know where I'm at, and I want to have headings and all that stuff so I can kind of keep myself organized. That's fine. Just do those in separate allegations that you're ready for them to deny. So, for example, let's say you get to the end of your breach section and you've got really kind of good, tight, concisely drafted allegations. Boom, boom, boom. You know, there was a banana, he walked down the aisle, there was a banana peel, he slipped on the peel, he fell and was injured. Maybe after some of that you've got a new allegation that's like, and therefore the defendant breached their duty of care. Now you're like, that's a free one. I know you're going to deny that one, but you're cool with that because you've got it on the other ones, and that's not serving a critical function for you, right? That's just a transition sentence or a marker for you to kind of be like, okay, I got through duty, got through breach, I'm on a causation now, I'm organized. It's like a jot down of an outline when you take your test, right? Anybody take an exam and that's closed book and they're like, ready, go, and you immediately just start writing your outline down, right? You might do that because you're like, oh yeah, what do I need to remember? Duty, breach, causation, damages, contracts. This class sucks. I hated it. I should have dropped it. Whatever. All the other things you want to remember, your legal points of law, and you might bring some of those to bear on here. Well, where you get in trouble is when you start mixing them in with your factual allegations. No. Keep them as separate numbered allegations. The minute you start inextricably intertwining your legal conclusion with a factual allegation, then they're just going to say, defendant denies paragraph 5. Oh my God! Paragraph 5 is like 7 sentences. Don't do that. Short, little sentences that gets out of the defendant as much as you possibly can. If the plaintiff's attorney, under the box here, frames the allegation in the conclusory way shown above, and if the defendant's attorney believes the defendant was not negligent, the defendant's attorney might deny the entire allegation. Thus, the plaintiff's attorney would learn nothing from the denial about whether the defendant's attorney believes there was water on the floor. I mean, if you're trying to get them, was there water? That's the issue. I mean, if a banana peel, we laugh, haha, banana peel, but I mean, if you're leaving banana peels on the floor in Kroger, that could open them up to some liability, right? If that's what the whole case is about, you want to know, was there a banana peel there, right? So if you say they negligently left a banana peel, you will have learned nothing. But if you say there was a banana peel, period, next allegation, they negligently left the banana peel, well, you've got kind of superfluous allegations to some extent, but you'll at least be able to glean something from the first one, even if they deny the second one, okay? Pleading alternatively and inconsistently, you can do that, right? This is a less important point, but you can set actual or statements of a claim or defense alternatively or hypothetically, right? And states, I think, generally have rules. Like if you don't know why the gate was open, you could say, well, it was left open, or something opened it up. I mean, you could plead inconsistent theories. There's nothing wrong with that, but that pales in comparison to the importance of alleging in a neutral way. I said it last semester, I've said it before, and lawyers never do this. They're so keen to win the argument, win. No, just allege facts, get information out. This isn't as much about persuasion, it's about kind of neutrally alleging facts. Organizing the allegations. I mean, this is it right here. Look at the sequence of the allegations. How are you going to organize your complaint really well? How is that going to be? Is it just going to be about on this date, on this date, on this date? Is it just a chronological sequence of events? No. Take your elements of your cause of action. If it's offer, acceptance, consideration, do the facts first with respect to offer. Then do the facts with respect to acceptance. Then do the facts with respect to consideration. If it's duty, breach, causation, damages, look at how they've done this, right? Example on the box on page 31. Beautiful, right? Premises liability. This is what yours is going to be, right? This Porsche Pond case. Basis of the defendant's duty. Defendant owned and operated a grocery store. Plaintiff was, this is like my case, right? Plaintiff was a customer at defendant's store. Notice that they have basis of defendant's duty. This should be numbered, right? It might be like A, basis of defendant's duty, 1, 2, B, 3, 4, 5, C, 6, 7, right? But that's kind of what it would look like. Now this basis of defendant's duty, that's a legal conclusion. It's really a heading, but it kind of will function as a legal conclusion that they're not going to admit. They'll probably disregard it because it's not properly alleged as a numbered allegation. But even if it was, it would be disregarded, but it's not there. It's just serving it's like a signpost. Hey, this is the duty shit right here. Here's the duty allegations, boom, boom. Here's the breach allegations on that date. Water or some other liquid spilled on the floor. Kirby, I think a spilled's there, but I think that's neutral enough, right? It wasn't negligently spilled, then you might have a problem. Defendant knew about the liquid or had sufficient time to become aware of that. What do you think about that one, Anthony? Is that a good allegation? Defendant knew about the liquid. I'm on the bottom of page 31 in that box.
I mean, they would deny that.
Are you sure? What makes you think that that's not as good? New.
What?
I mean, why do you... No, I'm not compared to anything. I'm just saying, like, defendant knew about the liquid on the floor. Let's say you're the grocery store owner in this hypothetical, and I'm the customer. Obviously, I slipped and fell on some liquid that was on your floor, so it's like my Kroger hypothetical. And I allege that the defendant knew about the liquid on the floor and you had sufficient time to become aware of it. And you're like, they would deny that. But why? Do you think that that's a good allegation just generally in a case like this? If so, why? If not, why not?
Well, it could be good it could be good in the sense that if they deny it later, if we come back and let them do that.
Yeah. What now compared to the one below it? Defendant negligently failed to remove the liquid from the floor.
Well, you're automatically jumping into a legal conclusion on the last one.
Yeah, I mean, I think your reaction is right, which is that last one, that third one there, defendant negligently failed to remove the liquid. That looks like that is a legal conclusion, and defendants are less likely to admit that. Knowledge, I think students have this reaction that's like, oh, knowledge, maybe that's too tough a road to hoe. I don't know that I believe that though. You either did know or you didn't. Now, can you prove it? That really is not what's at issue here, right? I mean, yeah,
My problem, I mean, I was kind of with him on that.
and we all kind of are.
Because it's two choices in that one. And
No,
they're
that's a
talking-
good question,
They're
yeah.
talking about sufficient time. Well, what's sufficient time?
Yeah,
If
no.
I'm gonna go that road, then that's why I was immediately, you can deny that one easily.
Yeah, I think that's probably true. That's actually a good point. I didn't even think about the sufficient time till you pointed that out. I think that's probably right. Sufficient time, but just you shouldn't want to shy away just purely from knowledge, right? Because just knowing something or not knowing something, I mean, that is a little bit in the eye of the beholder to say. But you either kind of did know or you didn't. Sophia, did you know that tomorrow's your birthday? It's not, but tomorrow's your birthday if it wasn't. But we can't class. Did you know tomorrow's your birthday? She either knows it or she doesn't. Do you know that there's coffee in here? You either do or you don't, right? Now, did you have sufficient time to become aware? I think, yeah, that's gray enough that I don't know that I would call it a legal conclusion, but it's just too ambiguous of an allegation, right? But what about the first one? On that day, water or some other liquid had spilled on the floor. That's an alternative. What do you think about that one?
I think they don't have a choice there.
I think you're
Because
right.
If it's not water, it was something wet. And so if they just put water, that's gonna easily be a deny.
Yeah, if it was something else.
If it was
yeah,
gas or-
exactly. Yeah, I mean you're on it, which is like you're starting to get these things tightened up, so that you're kind of boxing them in. Like we're gonna admit it, I'm gonna deny it. Now there is that. We'll talk about answers down the road, a couple weeks, and we'll talk about like ways they can weasel out of it, which is like I don't have enough facts to state, but that's like bullshit. If they do have enough facts to state, they gotta state. They can't be like, I don't know if my birthday is tomorrow. No, you either do know or you don't. Like there either was water or another substance or there wasn't. So you want to kind of think about drafting these things in a way that avoids words like negligent, avoids the legal conclusions, avoids sufficient, adequate, enough. Yeah, all of this. You want to get stuff out of the defendant, right? Narrow it down, prove up your case, right? And the way you do that is actually, in a way, less, not persuasive. Because in a way, I think, see, the reason why I keep coming to your persuasive thing, Anthony, because I'm like, to me as a lawyer, I think, the most persuasive complaints are the most neutrally written ones. It's kind of like having the goods to back it up. It's like speak softly and carry a big stick, right? It's like, you don't need to use it. The minute you see people using bluster and he was negligent, it's like, no, you're just talking a big game. Like, prove it. And the real persuasive complaints, I think, as you become, in practice, you see a lot of these. You're like, the best complaints are the ones that are the tightest, the most concise, the best well-written, the most neutral facts. Then you're thinking, this is a good complaint. This is persuasive, right? I think this is effective, is maybe the word I would use. What's the most effective? And infecting it with otherwise seemingly persuasive language isn't the way to go, okay? Neutral is the way to go. But you might just kind of highlight this box or something, or keep this in mind, because this is kind of what it looks like. These are the elements. Now, they're not all great, right? Some of it caused is a little bit of a gray one, but a lot of these are written in a pretty effective way. And it's really organized. Duty, breach, causation, damages, and that's all you do. Grouping facts into paragraphs. What about that? Let's go back to, tell me your name. I'm getting all the names. Hannah, April, Anthony, Kirby, Michael. Oh, there's another Mike. Is this guy Michael? Mitchell. I'll never get it. Michael, let's go to you. What about this? Grouping facts into paragraphs. What's the lesson here?
It kind of goes, I think, to the conciseness, because each paragraph has to be limited as far as practicable to a single set of circumstances.
Yeah. Yeah, what they're basically saying is if you've got discrete concepts, factual allegations you're trying to put forth, put them forth in separate numbered paragraphs, right? Only try to prove up one fact in that paragraph, right? It goes to this idea of numbering your paragraphs, right? We recommend that each paragraph address no more than one element of the cause of action. Don't start mixing duty allegations and breach allegations and causation in one numbered paragraph. I mean, stop for a minute. Spoiler alert, when we get to answers, you're gonna have, if the complaint has allegation 1, allegation 2, allegation 3, allegation 4, spoiler alert is when you get to answers, I'm gonna teach you that the defendant has to draft an answer with numbered paragraphs that correspond to this one, and the answers are easy. Admit. Deny. It's really hard. This would be a tough drafting exercise. Right? Admit. Right? I mean, it'll say like, defendant admits that out. But that's it. That's it. Or lacks sufficient knowledge. It's not like an essay. It's like sentences. And then you might have, and you will, and you'll see this when we do it, then you'll have affirmative defenses. What's an affirmative defense?
Said it last class.
What is it? Come on.
We said it last class.
Yeah.
I can do maybe examples, but
Okay, we'll do an example. That's fine.
statute of limitations.
Yeah, statute of limitations. Okay, so but if you know that, though, I mean, you think like a lawyer. You know that the statute of limitations is an affirmative defense. So what is an affirmative defense?
Something that causes the case to like stop, pretty much.
Yeah, it causes the plaintiff to not win, right? I mean, if their claim is barred by the statute of limitations, they necessarily lose, even if what?
Even if.
It's true.
Yeah.
Yeah, you see y'all, the good law firm right here. This is
There
going to
we
be a
go.
good law
There we
firm,
go.
right? Yeah, right. Even if all of these allegations are true, you still lose. Sucks for you. Why? Because your claim is barred by the statute of limitations. Like, I got one on my desk right now. I'm doing this whole thing. It's like, well, it's kind of good, but you waited. Why'd you wait so long, right? Or release. Hey, you know, great, Colin. You've got this beautiful negligence premises liability complaint, but remember, you all settled the case. They sent you that check and said if you cash this at Chase Bank, that releases us from liability. It's a release. And you cashed it. And you went to Cabo. It was great. This didn't really happen. That would be a release. That would be a defense, right? Statute of limitations, accord and satisfaction. I mean, we can learn all about defenses. Those are going to be alleged in the second part of an answer, right, potentially. Why did I bring any of that up? I brought that up to say, if this is what's coming back, admit, deny, admit, if you start putting multiple allegations, 6 in one paragraph, they're going to just deny them, right? Because it's like, what I'm kind of teaching you with this inextricably intertwined is, if there's something in here they're going to deny, and you put all this in here, they're just going to write deny. And you're not going to know, well, did they really admit this? Was it this that caused them to deny? Was it that? Was it the whole thing? That's why you want it short, punchy, tight, concise, neutral. Colin walked into Kroger on that date. True or false? Admit. Colin slipped down a banana peel. True or false? Slipped. What does it mean to slip? I mean, now I think you could say slipped, right? It's not like, let's not get too cute, right? He slipped, right? Fell. Colin made contact with a banana peel, period. Colin proceeded into the air, period. I mean, we don't have to be ridiculous, but that's kind of what you want. You don't want to say, Colin tragically launched into the air because of the abysmal conduct of this, massive corporation that paid nothing in taxes last year. Bernie! No, that's like insane. You don't want to include all that, right? So you get what we're saying. Keep it short, keep it simple, because you want to see what's coming back from the other side, right? Admit, deny. So numbered paragraphs. Cross-referencing between paragraphs, that's not something we have to think about too much. I mean, that can kind of work. You might say, oh, well, as stated above. Oftentimes that works if you're trying to use an allegation or a part of your complaint as a signpost, right? Defendant negligently failed to remove or repair the condition described in paragraph 8. I mean, it's probably going to get denied, right? That's very legalistic, legal conclusion language. But if it's serving as a signpost, you could kind of see the benefit of it. I almost hesitate to tell you about the whole, include legal conclusions as a signpost, but because then I think students will be like, oh, what about legal conclusions? You said we can include them. Well, you can, but they're not doing the work for you, right? They're not doing the work for you. It's like I don't know how to describe it. It's like, It's like if you had movers moving furniture in a house, and you were all movers, and you moved a box, and you moved a box, and you're all working. You're a worker, you're a worker, you're a worker. And if after 3 of you go, I'm like, good job, you did a great job. You did a great job doesn't do anything, but it's there, it might serve a purpose, right? But it's the workers, it's the sentences that's kind of stupid. My parents live with me because they're in between moves and I just want them to get the hell out. So I'm thinking about movers, they're moving at the end of the week. It's been 4 months, it's been a dark road. But yeah, those workers are all doing something, right? And so, some of this is gap filler, but gap filler can do something if it keeps you organized and structured and serves that kind of a stylistic purpose. Okay, any questions? I think we've gotten through most of it. We've beaten a dead horse, but I want you to kind of keep going back to this material because what we're gonna eventually draft, not this for this Saturday, but for the next Saturday, an actual complaint, and I think you'll have to reread that material in preparation of that. That said, we're going to take a few minutes now because we're going to do another drafting exercise for next class. And so I want you, if you don't have it printed, which you probably don't, but if you are online or you can follow along here, let's go on Twin. We've got the home page, which is Google Drive. Does any other courses use Twin?
Evidence.
Evidence. Admin. Chevron deference. You all learned about that?
I have.
You have.
In environmental.
It's the best.
There's a YouTube video.
Well, that'll teach you. I love evidence. And evidence. Okay. This isn't working because it's crappy. Drafting exercises. Is yours working?
Yes.
Okay, well, I have a hard copy, so what you would do is go to drafting exercises, there's a 4th folder, you click on that, you open it up. You have to actually download it, because if you do the view, it looks like crazed, but then the minute you download it, it will look like this, right? Now, I used a version of Porsche Pond last semester, but this is different, right? I mean, this is not the same. First of all, I mean, you need to be using your own, work, like honor code and all that. But this is also a new version of Porsche Pond that looks different than I did last semester. And we will continue to use new exercises going forward. But it's the same idea, which is, because I like this, premises liability complaint, slip and fall. So let's go look at this. Porsche Pond fact pattern. Your client is named Porsche Pond, and this comes from the Temple Smith couples case. Your client is named Porsche Pond, and she runs a cleaning business known as Old Town Commercial Cleaning. On November 1st, 2019, Porsche was injured while she was performing janitorial services at Grantham's Jewelry Store, which is owned by Philip Grantham. Your paralegal recently interviewed Porsche and learned the following facts. A, while Porsche was cleaning Grantham's Jewelry Store, she went into the employee break room so that she could clean the room's linoleum floor. However, as Porsche went inside the room, she slipped and fell on jewelry cleaning solution that was on the floor. You guys are going to think I'm going to have some session with slip and fall cases. But they function well for a first-year drafting class or entry-level drafting class. B, someone had left a 5-gallon bucket of now this is not a complaint. You're like, oh, these are bad allegations. This is just your paralegal interviewed Porsche and got her story. And maybe she wrote this email to you or wrote a memo to you that it's like, hey, here's what happened to our client Porsche. Someone had left a 5-gallon bucket of jewelry cleaning solution in the area near the sink. The bucket had either leaked onto the floor or a spigot attached to the bucket had been left in a position to cause fluid to drip onto the floor. C, on 3 prior occasions, Porsche had cleaned up fluid from the area around the same 5-gallon bucket. On each of those occasions, after Porsche cleaned up the fluid, she told Mr. Miles Minton, the manager of Grantham's Jewelry Store, about the fluid that had been on the floor. D, the employee break room is under the exclusive control of Grantham's Jewelry Store and its employees. The break room is not accessible to the public. E, as a result of her fall, Porsche broke 2 bones in her arm and 2 bones in her hip. Are there 2 bones in her hip? Are there 2 bones in her hip? Is the hip just 1 bone? I don't know. Let's just go with that. Porsche also had to have hip surgery, and she went to physical therapy for 3 months so that she could learn to walk again. That said, Porsche is still having trouble walking, and her doctor tells her that she may have to use a cane for the rest of her life. F, Grantham's Jewelry Store is a sole proprietorship operated by Philip Grantham. Grantham's Jewelry Store is located at 212 Tennant Street in the city of Old Town. that should say which is, not which is, which is located in Caledonia County in the state of Kentucky. So it's fake, it's a fake state, right? Kentucky, sound familiar, right? Caledonia is the name of the county, Old Town is the city. So then that's the facts. Let's look at this memo, which is the practical effect of Kentucky Rules of Civil Procedure. It's just kind of like the procedural rules you ought to think about. Like, it's a fact-pleading state. What does that mean? It's this whole thing that's like you've got to allege enough facts to meet each of the elements of the cause of action, which would here be premises liability, which of course is a negligence cause of action. Jurisdiction. The Kentucky Superior Court has jurisdiction over cases involving damages in excess of $20,000. So this is not a federal court, it's a state court. The court has jurisdiction if damages are over $20,000. If the amount is more than $5,000 but not more than $20,000, it's in district court, right? If it's less than $5,000, it's in the small claims division. The Kentucky rules require the plaintiff to plead the grounds for jurisdiction. The Kentucky long-arm statute's there. Venue is there. Damages, laws about damages. You could read over some of this stuff. These are just procedural rules. Signing and captioning, how you have to sign the complaint, how it needs to be captioned. And look, there's the elements of premises liability action. Let's look at these. In Kentucky, a person who owns or is in control of or possession of premises has a duty to keep reasonable care to make the premises safe for a business invitee, a person whom a commercial entity invites onto its premises in the hopes of gaining that person's patronage. The following is an outline of the elements. And I think they're trying to get across here that that would be applicable to someone like her, because maybe she's not a member of the public, right? She's doing business with them, but I think it's pretty clear they would owe her a duty of care. So the existence of a duty of reasonable care arising from the defendant's possession or control of the relevant premises. Breach consisting of both the following. Existence of a hazardous condition that the defendant either knew of or had sufficient time to become aware of, and defendant failed to remove, repair, or otherwise correct the condition, or failed to make reasonable efforts to warn the plaintiff. The breach proximately caused personal injury to the plaintiff, and as a result of the breach, the plaintiff suffered damages. Okay, so it's duty, breach, causation, damages. The statutes, the elements are written in a little bit of a hokey way. Like I would have said, like the breach was both the but-for and proximate cause, but whatever. I mean, it's all there, right? Those are the elements of the cause of action of premises liability. So you don't have to go do a bunch of outside research. It's here. Procedural rules, substantive legal rules. So what do you have to do for next class? Well, nothing hard, right? Assignment A. You have two assignments, A and B. A. After reading the memo and the facts above, answer the following questions. Do you think you have sufficient facts to establish a cause of action in Kentucky? Do you think you have a cause of action in Kentucky for premises liability? If you read over Portia's complaint, what do you think? And say why or why not. Which court would have subject matter jurisdiction? Why? Can it be filed in Caledonia County? So are you thinking about Superior Court or are you thinking about District Court? How many potential defendants do you have? What was the basis of each potential defendant's duty? What was the nature of the defendant's breach? Regarding the breach, were the defendants acting together or separately? I mean, there really are only two defendants, it seems like. I doubt you're even going to want to use the manager as one. You just told him that, but you don't know anything about him. It's probably just one Granthams, right? What are the ultimate facts that support each element? What weaknesses do you notice in the case? What's the point of doing that? The only point of this is really just, this is kind of what it's like. I mean, these aren't the best questions, to be honest. This is what comes from Temple Smith and Couples. I want you to answer these questions. It doesn't have to be long, a couple sentences for each one. The point of this, though, is you're taking a fact pattern that you get from a paralegal, and you're starting to think about putting together what you would need to draft a complaint. You're not drafting the complaint here, but you're thinking to yourself, like, hey, if we filed a lawsuit, where would we file it? Would there be jurisdiction? What court would that be in? You know, what do we have enough facts here? What are the facts that go to duty? What are the facts that go to breach? What are the facts that go to causation? What about damages? Does she have that? Does she not have that? What's weak about her case? I mean, she seemed to know an awful lot about these slips and falls. I mean, I walk into the room, oh my God, there's water everywhere. Let me clean it up and tell somebody. Next week, oh my God, there's water everywhere. Let me clean it up and tell somebody. Next week, oh my God, there's water everywhere. Let me clean it up and tell somebody. Fourth time, ah! It's like, well, maybe she should have been on notice that, like, every time she walks in there, all those things. And what about affirmative defenses? And some of this is beyond the scope, but the whole point of the exercise is just in a calm way, with a beer or a cup of coffee or a glass of wine, whatever you do, just read over this and start answering these questions. Think about it. Just, you can answer questions beyond this. You can jot notes down. You can brainstorm as if you were maybe going to have to draft a complaint using these facts. Okay? Then, B, it'll be better with a beer. B is critique a premises liability complaint. And it says you find a premises liability complaint in your firm's files set out below. And if you look at the next page, look, there's a sample complaint. We'll talk about it in a minute. It says, review the list of elements set out in the memo. Review chapter 1, which is this whole procedural matters regarding complaint. That was the general introduction that you read. Chapter 2 is this reading material for today. And it says, answer these questions. Does the complaint contain a proper caption? So A is, hey, you got a fact pattern, Portia Pond, and you're starting to think, like, maybe I'll have to draft a complaint. Like, is this good? Is this good? What's the strengths? What's the weaknesses? Where might I file a lawsuit? Blah, blah, blah. B is like, hey, what is this firm that I now work at done in the past with complaints? What does theirs look like? Let me see what one looks like and see if it's any good. Does it have a proper caption? Is there proper commencement? Is the jurisdictional allegation correct? Does the paragraph deal with a single element? Is it a good complaint? Answer those questions, right? So you'll have 2 assignments, but you'll just turn it in as one. Look at the complaint. Just look at it. Plaintiff versus Blue Lake Club. I love the title. In Kentucky. Where? The complaint. The complaint! And now comes. What firm do you work for? Resign and go work for somewhere else. No. And now comes Susan Braintree, also known as Braintree, or hereinafter Braintree. How many times do you see that? Complaining of defendant, alleging this action is for damages. The matter in controversy is for damages in excess of $15,000. Pursuant to Pent law. What's Pent law? This court has jurisdiction of the matter. And then look at these allegations. Look at how long they are. 2, 3. What is 3? That's like 4, 5 sentences. Crazy. Blue Lake 4. Blue Lake negligently failed to post, right? I love 5. Plaintiff slipped, fell, and was really badly injured. Among other injuries that she suffered, she broke both legs. I mean, who drafted this? Oh, I love the ending. Wherefore, the plaintiff heretofore demands a judgment against the defendant, named herein. And then I love the signature from Adam Colchester, the attorney, as opposed to the other Adam Colchester. So it's a really shitty complaint, okay? But you might think, I mean, I want you to answer the questions. I'm not going to, like, evaluate each, did she answer? Number 2, did he answer? I want you to answer the questions, but if you feel the license to go a little bit beyond, if you want to edit the complaint, I mean, I know that's not like a fun thing to do, but feel free to take a little bit of license with how you answer the questions or the format you use. If you want to use bullets, that's fine. It's all really just to get you kind of thinking. I want you to reread the reading material. I want you to kind of use this stuff in an active way. Hey, if I had a fact pattern, what would I do? Think about scenarios just in your other classes. Like, hey, if this was a civil case, what would the allegations look like? How might I draft a Portia Pond complaint? What's the problem with the complaint that's already in our case file? What looks decent? What's bad? There's a lot of things that are wrong with it. How might you fix that to make it better in the future? Okay? So complete that kind of 2-part drafting exercise. Email that to me by next Saturday, this coming Saturday at 5 o'clock. Bring a hard copy to class next Monday. No new reading assignment, but keep thinking, because what's going to happen next is you'll either have something that you've already kind of seen, like the Portia Pond thing, or maybe a new fact pattern. But what's going to happen is we're going to talk about all this stuff, and then at the end of the class, next class, you're going to get an actual kind of, maybe a slightly more detailed fact pattern in the Portia Pond case. Elements, kind of rules of procedure, and you'll actually have to take your first stab at drafting maybe a substantive 1-count complaint. Okay? fair? Alright, guys. Get out of here. See you next class. Have a good week.